1 second. All right, I think we're ready. In 2021 647 for the Mr. Ramirez. Torel Nichols is here for the state. Mr. Ramirez is appearing by phone. So, Mr. Ramirez, I generally have a what I call a calendar call the week before trial. I did try to call you. I think I left a message and rescheduled your for today. So you have your trial scheduled for tomorrow, and I just wanted to touch base with you and see where you're at with that. If you're ready to proceed.
Well, I still have a few unanswered clarifications on the table. I don't think we can proceed until those are addressed.
What are you looking for?
I said there's still unanswered clarifications on the table, specifically the factual evidence regarding the element of jurisdiction that the prosecution has failed to provide.
Have you filed written motions on those?
Have you looked at any? Have you looked at any of my motions I submitted or my objections? I can't hear him.
Now, Mr. Ramirez, if you don't, when you file a motion, you have to file it electronically. I only have, the last motion I have from you, well, there were two motions. There was a motion to recuse the judge, which I believe was resolved by another judge. And then there was a motion to strike the plea, which I believe, and actually both of those, my indication is motion to strike the plea, motion to refuse the judge were both resolved by another judge. And I do not have any other motion from you.
You didn't receive all my objections I entered?
I have received nothing.
Well, I entered 14 objections, and the state touched on one, and he didn't address the other 13.
Actually, here, I did receive on February 16th what's called a second appearance, initial objections, and demand.
Correct.
So that would have basically been, all motions have to be filed within 20 days of trial.
Okay.
That would have been outside the,
So all these motions that the prosecutor filed today, should they be thrown out as well because he didn't file them in a timely manner? According to Arizona 15.1, I requested disclosure under subsection E, and he failed to do so.
there is a, so have you filed anything beyond, what I have is a notice.
Did you get the Brady request and the discovery request? That was one of the first ones that was entered.
No, I don't have any of that.
Well, I have.
Mr. Amir, Here's what I'm going to do. It doesn't sound like you're ready to proceed.
Objection. I object to you saying that. I have a...
Well, if you're ready, then I'll have a jury here tomorrow. You'll need to be here at 9 o'clock. We'll proceed.
Well...
Is that what you tell us?
So,
If you're ready, then I'll get the jury here.
you just said that you just can I speak without being interrupted, please? And can we please only bring one issue at the table at a time?
Mr. Maris, you need to answer my question.
I'd be more than happy to address it. I'm not playing any games with you, but I'd be more than happy to address it.
Okay, Mr. Martinez, because if you do not answer my question, I've been trying very hard to help you get through this, and all I get is resistance. I'm trying to help. If you want more time, I'll give you more time. If not, I will have a jury here at 9 o'clock in the morning, and we will proceed.
Objection.
So what do you want?
Objection. Can I make record? You just stated about 7 things, and if I don't rebut to them, they stand as truth. So can we address one thing at a time, please?
Well, that's not. No, I need you to answer my question. Are you ready to proceed to trial at 9 o'clock in the morning?
Is this a prelim? This is to go over what's been going on to the case, correct?
Mr. Martinez, please answer that question. Are you ready to proceed to trial at 9 o'clock in the morning?
Well, last time you said I had the right to a fair and meaningful hearing. How is this fair and meaningful when you're asking the questions that you wish I would have asked and not the ones that I'm asking?
Are you ready to proceed to trial at 9 o'clock in the morning? Please answer that question.
I'd be more than happy to address it just as long as the clarifications on the table are answered first. So
I have no clarifications that have been filed before me. There's nothing in front of me. I need you to answer that question.
Well, you're alleging that trial is tomorrow, and I'm requesting factual evidence regarding the element of jurisdiction. Here, right now, I'm challenging jurisdiction. Has the state provided any factual evidence regarding the element of jurisdiction as of today?
Yeah, it's in the indictment, Mr. Martinez. They have to prove it to a jury.
So, are you suggesting, for the record, that the state has not stated this case?
Martinez, this is not a pretrial hearing. This is a status conference to determine if you are ready to proceed to a jury trial in the morning.
I called this morning, and the court reporter said this was a preliminary hearing.
Listen to me. If you want more time, I'm more than happy to give you more time. I will not make you come to Arizona and do a trial tomorrow, and we can have a hearing on your initial objections and demands, but I need you to answer these questions for me. Do you want more time?
Well, I can't answer that questions until you guys answer some questions first. I have yet to be informed of the cause and nature.
Mr. Martinez, you don't get to ask questions of the court. You get to answer questions.
So are you suggesting that I just have to answer questions and I'm not allowed to speak for myself or ask anything or question what's going on?
You can speak for yourself as long as you want, but you have to answer my question because I have to determine whether I need to bring a jury trial to this courtroom in the morning. That's the only thing I'm trying to figure out right now. And if you're not ready, I'm not going to make you proceed to trial. But if you are ready, then we can proceed.
Well, like I said, I'd be more than happy to address that. I mean, I'm asking for factual evidence.
It's yes or no. It's a yes or no answer, Mr. Martinez. You're either ready or you're not ready. What is it?
Can you not yell at me? Your demeanor, you seem really threatening right now.
I'm yelling at Mr. Martinez, but I have to speak a little louder because you said you couldn't hear.
Oh, I couldn't hear the prosecutor. I could hear you loud and clear, and it just seems like your demeanor right now. I'd just like to make.
Mr. Martinez, I need you to answer the question.
Can you stop interrupting me, please?
What's that?
Can you stop interrupting me, please? I mean, I'd like to make record if that's possible.
No, your only record you'll get to make is to answer the question. You're ready to go to trial or you're not ready to go to trial. So what is it?
Well, I just said earlier I'd be more than happy to address that, just as long as the clarifications are answered. Are you going to make a ruling on my objections?
What objection do you have?
The objections I answered.
You mean your initial objections and demand?
Yes.
All right. Let's go through that real fast. You have said that the alleged defendant agreed. I have no idea what you're talking about there. You have a touch-and-go landing, number 2. You have a shoring up, a leaning tower in the desert, I have no idea what you're talking about. You have a deceptive offer, a relevant, unanswered interrogatory. And the alleged defendant have the right to be informed. You received the indictment, so that's the notice. You have the Grand Canyon. A lot of what you're saying in these is really almost incoherent, Mr. Ramirez. And like I say, I
object to that. I object to that.
Hey, so I'm willing to give you a chance to argue your initial objections, but not today. I'll have to schedule a hearing. And if I schedule a hearing, then I'm going to vacate the jury trial. But the first thing I need to do is decide if you want to proceed the trial or not. Would you rather I give you more time so I can schedule a hearing? You'll have to appear, and then we will go through your initial objections and demands.
Well, since I can't get any findings and conclusions for any denials of the motions, and since the court refuses to object on all my objections, this is an issue that really needs to be addressed by the interlocutory appeal. I have every intent to immediately file a motion, and in fact, trying to proceed before that's been ruled upon will drastically harm these proceedings and my rights in these proceedings. So, Judge, what is the process by which we now address my problem?
Your problem. This is the process. I'm gonna vacate the jury trial tomorrow. I'm gonna schedule a hearing on the state's motions and on your initial objections.
I object to that. You have yet to answer what's on the table.
Here in person, I will schedule that hearing on.
Well, I object to this. I have a few clarifications. I have the objections and demands. This is an issue for interlocutory appeals. Even proceeding with this is.
Listen, I mean, you accuse me of interrupting you. You don't even let me finish.
You haven't let me finish this whole time. You haven't let me finish this whole time.
Now you're interrupting me again.
Objection. No, I'm trying to make record. You won't let me make record.
March 24th, 9 o'clock, hearing on all motions. You will need to be here in person. If you fail to appear at that proceeding, I will issue a warrant for your arrest.
Did you say March 24th?
No, I just said.
I can't hear. That's why I'm saying you're saying so many things at once. You said March 24th?
March 24th, 9 o'clock. You must be here in person.
Well, I object to that. I mean, why can't you answer the objections today?
The objection is overruled. March 24th, 9 o'clock.
Are you going to deny the state's motions as well because he didn't file them in an orderly fashion? He's well beyond the time of.
Well, you can make that motion on the 24th.
Are you going to rule on that today?
No, I'm going to rule it on 24th.
So are you refusing to rule on it today for the record?
Mr. Ramirez, have a good day. We'll see you on the 24th.
I object to that. I object to this whole proceeding.